Thanks for joining us again for this ongoing series we're doing. A few episodes this summer. In fact, this is the fifth of the installations that we're doing that deal with the question of the United States Republic, our constitutional republic, and I'm arguing that much of the apparatus that goes into our constitutional framework and so on can be derived ultimately from the Bible. Certainly that was not much of a debatable point 100 years ago, but these days it's a bit of a more embattled idea. And so I thought I'd weigh in at least and give you my thoughts on the subject, and I hope this has been interesting to you. We probably won't be doing any of these for at least another few weeks. You know, if you're watching these in real time, you know we're in the middle of the summer, and during the month of August I'm going to be doing some traveling and so on, so we may not get back to this until a few weeks down the road. But I appreciate your interest, and I hope you'll be able to join us when we do get back to putting some more of these online. If you're paying attention, you know that we're in the middle of a series on the Gospel of John in the class that we do in church, and I'll be uploading those beginning in September, so that's about a couple of months out, something like that. Anyway, right now we're dealing with this question of the biblical roots of the American Republic. There are some, of course, that would really fly into a rage, I might say, at the proposition that the United States was founded on biblical principles, but actually historically it's not all that tough to prove, and in fact it was the working assumption among knowledgeable people really for the first 150 or so years of our history, maybe more than that. I'm thinking, for example, of the Chief Justice of the United States back in the mid-50s, the mid-20th century, Earl Warren. No one would ever accuse Earl Warren of being a great conservative. He was, let alone someone that pandered to the religious right. But nevertheless, you read some of the things that he said, and it leaves little doubt as to where he was on the subject. For example, in 1954, he gave a speech to the International Council of Christian Leadership. There was a prayer breakfast. He was the featured speaker, and he spoke to the issue of what he viewed as the traditional classical substructure of American Republican ideas. And he said, quote, "I believe no one can read the history of our country without realizing that the good book and the spirit of our Savior have from the beginning been our guiding geniuses. Whether we look to the first Charter of Virginia or the Charter of New England or the Charter of Massachusetts Bay or of the Fundamental Orders of Connecticut, the same objective is present: a Christian land governed by Christian principles." It sounds a little bit out of place, doesn't it? But this was the Chief Justice of the United States Supreme Court speaking in the mid-20th century. He said, quote, "I believe that the entire Bill of Rights came into being because of the knowledge our forefathers had of the Bible and their belief in the freedom of belief, of expression, of assembly, of petition, the dignity of the individual, the sanctity of the home, equal justice under the law, and the reservation of power to the people. All of those he saw as derived from biblical sources, and it was for that reason that he really argued that the Constitution was a distinctively Christian document. As unlikely as that may sound these days, and some people would, of course, really be rocked by the idea that such a thing was true. Nevertheless, historically and traditionally, that was more or less taken for granted. Again, Earl Warren says, quote, "I like to believe we are living today in the spirit of the Christian religion. I also like to believe that as long as we do so, no great harm will come to this country." Really, of the five presentations we've done this summer, I think this is the most important of them. This is the one that'll probably be the most challenging case to make in some people's minds, and yet I don't think it's a tough case at all, and I hope you'll be able to kind of patiently work through the material with me as we think about this question. The point I'm getting at least in a preliminary way, is that traditionally America was viewed as a Christian land governed by Christian principles. And you would find repeatedly presidents of the United States throughout the 20th century said as much on various occasions, including Woodrow Wilson, Franklin Delano Roosevelt, Harry S. Truman, Jimmy Carter, all of them, by the way, Democrats, and you could easily find the same kind of affirmations from Republican presidents of the United States as well. You find the same thing stated in pivotal Supreme Court cases. Church of Holy Trinity versus the United States. I'm giving you the sites here because if you want to go to the trouble of typing in the site into Google or something like that, the case will come up and you'll be able to read it for yourself. But this 1892 case stood for the same idea, took it for granted. The United States versus McIntosh, 283 U.S. 605, 1931 case. A 1952 case, Zorrock versus Clausen, in which we hear the Chief Justice of the Court, William O. Douglas, announcing the following: the First Amendment does not say in every and all respects that there should be a separation of church and state. This is the Chief Justice of the United States Supreme Court saying in a judicial opinion, writing for the majority, the First Amendment does not stand for some kind of absolute separation of church and state. He says otherwise the state and religion would be aliens to each other, hostile, suspicious, even unfriendly, which obviously from the point of view of William O. Douglas was not any state of affairs that should be countenanced. He said, quote, prayers in our legislative halls, the appeals to the Almighty in messengers to the chief executive, so help me God in our courtroom oaths. These and all references to the Almighty that run through our laws, our public rituals, our ceremonies would be flouting the First Amendment. He says a fastidious atheist or agnostic could even object to the supplication with which the court opens its session, referring to the sessions of the Supreme Court of the United States, in which the announcement is made, God save the United States and this honorable court. It's taken for granted. This was the classical view. This was certainly the view that was more or less the kind of culture in which those of us who were older grew up in and more or less took for granted as the currency of the realm. But of course, today we have a somewhat different vision, don't we? We have a very different culture. What a change has taken place in a scant 40 years or so. Interestingly, in 1996, just a little over 40 years from the time that Chief Justice Warren gave the speech I just mentioned, Justice Antonin Scalia addressed a gathering of the Christian Legal Society. He was the featured speaker there. In this case, he didn't say anything about the United States being a Christian nation. He didn't speak of the classical idea that was taken for granted by presidents throughout the 19th and 20th century. He didn't say anything of that. All he did was give his personal testimony. As a Christian man, he was explaining how he had tried to work out the details of his faith in connection with, of course, being a prominent public figure and serving on the U.S. Supreme Court, and he gave a very candid and personal recitation of some of the challenges that had faced him in that regard. Nevertheless, that particular speech that he gave to the Christian Legal Society in 1996 produced a firestorm of protest. There were calls for his resignation. There were many who thought that what he had done was stepped so far out of the bounds of what was appropriate for a U.S. Supreme Court justice that he had no right being on the high court. John Newhouse wrote in A Strange New Regime, the Naked Public Square and the Passing of the American Constitutional Order, part of the Heritage Lecture Series. This was number 57. Or I should say number 572. It was published in October of 1996, and he says the following concerning the speech by Scalia. Unlike Earl Warren, from 40 years earlier, Scalia did not set forth religious and moral truths that he claimed were normative for the country. Scalia didn't do that. He didn't do anything as brazen as Earl Warren. Rather, he continues, he gave a personal testimony and discussed the difficulties in being a Christian in a thoroughly secularized sectors of our elite culture. This was news. This was scandal. And the pundits weighed in with alarmed commentary on Scalia's alleged challenge to the separation of church and state. You can imagine the secularists in our culture who were so completely offended by a U.S. Supreme Court voicing his own personal, private Christian understanding. Not only is it no longer permissible to suggest that Christianity is socially normative, as Earl Warren did, it's now no longer permissible for a justice of the Supreme Court to declare in public his personal allegiance to the Christian faith. How far we've come. How much has changed in that 40 years from the time of Earl Warren to our present situation? There are some, however, that have celebrated this transformation and viewed it as a very positive thing. There was a book written in 1996, the very same year, by two legal scholars, Kramnik and Moore, entitled The Godless Constitution, in which they said on page 27, God and Christianity are nowhere to be found in the American Constitution. The U.S. Constitution is a godless document, they opined. The Constitution has nothing to say about the social value of the Christian belief or about the importance of religion for a moral public life. That was the position they took. That was the position they argued in this book, trying to bring a devastating critique against any idea that the Constitution or the American Republic itself was founded on any kind of Christian ideals. Well, I just want to ask you, is that true? Is that actually consistent with our own history? In other words, can I put it to you bluntly, is God in the United States Constitution? That's the question on the floor, and I'd like to at least address it in some ways as we proceed here. You know that the U.S. Constitution is in three major parts. There's a preamble, which begins with the famous words, "We the people of the United States to form a more perfect union, to establish justice, secure domestic tranquility," and all of those things do ordain this Constitution of the United States. It's a wonderful preamble, well worth reading. I used to have students memorize the preamble because it's so rich in its meaning. Then you have the body of the Constitution, 7 articles. The first 3 outline the branches of the U.S. government. The first is the legislative branch, the most powerful. Then the executive branch, the second most powerful. And finally the judicial branch, the third. The other 4 articles work out ways in which the rules of the Constitution are to be implemented. And all of that gives a very practical design to the way in which our constitutional republic is going to be organized. And then at the end of that, we have a subscription, a very important paragraph, brief, but of course it is the point where the signatories to this Constitution that had been developed by the Constitutional Convention and would then be submitted to the several states for ratification, it was where they themselves put their names on the line, where they become the endorsers of this entire document. That subscription is well worth reading. It says, quote, "Done in convention by the unanimous consent of the states present, the 17th day of September in the year of our Lord, 1787, and in the independence of the United States, the 12th. In witness whereof we have hereunto subscribed our names." Just a couple of things to note in passing. I'm sure you caught it. For one thing, it's the year of our Lord, 1787, referring, of course, specifically to the Lord Jesus Christ. And also, of course, we have a reference to the independence of the United States and measuring the production of this Constitution as the 12th year, or in the 12th year, of the independence of the United States. All right. Well, if you think about that, you realize that the subscription to this Constitution celebrates 2 birthdays. On the one hand, we have the birthday of the Constitution itself. September 17th, 1787, that's the birthday. That's the day that all of these who had worked so long and so hard and through some fairly challenging sort of difficulties and so on had finally reached an agreement, concurred in the outcome. But that phrase, the year of our Lord, is a rather telling phrase. I know some people think, well, that's just pro forma. You know, everybody signed their documents that way. No big deal. Well, in fact, it was a big deal. A much bigger deal than we probably assume these days, because we've taken that calendar for granted. But that particular reference was based on what's called the Gregorian calendar. It's called the Gregorian calendar because it was developed by Pope Gregory the 13th, who was the Pope of the Catholic Church between 1572 and 1585. And under his rule, this particular calendar, which traced its history back to the traditional life and so on of Christ, was developed. So it's called the Gregorian calendar. Interestingly, when it was first published, it was immediately accepted by Catholic countries, mostly in Southern Europe, for obvious reasons. However, there was a fair amount of reticence in Northern Europe, where the Protestant religion was more dominant, and many people were quite hostile to adopting the Gregorian calendar. And in fact, in England, the Gregorian calendar was not adopted, listen to me, until 1752, which is only a couple of decades, you know, before the American Revolution. It took that long for England to embrace this so-called Gregorian calendar, which would use the language that we find in the Constitution. Between 1606, the founding of Jamestown, and 1752, which was the year it was adopted, England and the colonies both had been under the Roman calendar. And under the Roman calendar, there would have been a different designation. In other words, this was a fairly recent and somewhat controversial set of words to use in the subscription to the Constitution, and believe me, it was done consciously. This was no accident, and it was certainly no pro forma kind of a use of language that just everybody used without much thought. You know, that was certainly not the case. It tells us that the American Revolution, whatever else it was not about overthrowing the English religious outlook, which of course at that time was still thoroughly Christian. Now, we had some pretty significant differences of opinion as to how that Christian religion was applied and worked out, but fundamentally, of course, we agreed with England that the Christian outlook was the outlook that was to be embraced. And so this was not a revolt against England based on any kind of religious objections. It was a revolt based on the notion of consent of the governed. It was a revolt based on the idea that it seemed England was usurping the rights it had as the sovereign. It was violating the Magna Carta that had been there for centuries. It was taxing without representation. Those were the fundamental objections in the revolution, but this undergirding idea of a Christian outlook was certainly not the issue that was in play in terms of the revolution. This was the calendar that was accepted. It was a fairly recent recognition in England and in the colonies, and it was a quite conscious decision to therefore affirm in the year of our Lord, 1787. There was another revolution that took place, famous one about the same time. It's called the French Revolution. The French Revolution, of course, did object to the Catholic tradition, the Christian tradition. It overthrew the idea of theism. It put up the idol of reason and wanted to worship Lady Reason, you recall, in France during those days. It established a new calendar. It named year one, the year of the French Revolution. It changed the weeks. Instead of a 7-day week, it was a 10-day week, and so on. And in all of those, trying to sabotage and repudiate and get rid of this whole Christian tradition. The Constitution, on the other hand, of course, did nothing of the sort. The Constitution reflects a Christian understanding. In fact, even in Article 1, Section 7, you'll find that special deference is given to the day Sunday, because Sunday was the day that Christians recognized as a day of worship, and thus the Constitution itself recognizes that particular idea. So, the first birthday that we recognize and see is celebrated in this subscription to the Constitution is, in fact, the calendar that reflects or the birthday that reflects the calendar that had been put in place by Pope Gregory and was based on Christian understanding. The second birthday that's also noticed here is, of course, that the Constitution was finished, finalized in the 12th year of our nation's independence. Well, if you take a look at a calendar, you realize that they were in the 12th year, measured back to 1776, and the use of the word independence immediately tells us that the idea in mind was the Declaration of Independence. Lawyers would say this is an incorporation by reference. The Constitution is incorporating by reference the Declaration of Independence. It is, if you could say, part of the preamble to the Constitution was the Declaration of Independence. It's not recited again, it doesn't need to be, but nevertheless, the very reason that it's mentioned here is to remind people that that was the founding document. That the United States was not created when the ratification of the Constitution was completed. The United States was created as a nation in 1776 in the eyes of the people who are writing this Constitution on July 4th, 1776, with the authorization of the Declaration of Independence. And you find that again in the preamble, the same idea is there. It stated that this is intended to form a more perfect union. Well, you see, there was already a union. You can't talk about a union of a nation that doesn't exist. The nation existed, but the union of the several states needed to be perfected. Under the original Articles of Confederation, there was some real difficulties, and most people recognize that, and we're trying to figure out a way to improve on it, and that's what the Constitution was doing. The preamble makes specific reference to securing the blessings of liberty. Well, you recognize that language from the Declaration of Independence. Governments, human governments, are instituted among men to secure the rights that are in fact given to us in an unalienable way from God. And this is the same idea that's being suggested there. You read in Articles 1 and 2 that people who are candidates for various governmental offices must have already been citizens. You say, well, you can't be a citizen of a nation that doesn't exist. The United States existed, it already was there. The Constitution presupposes it, and thus the Constitution is basing, at the level of its presuppositions, the idea that there is a nation based on and created by the Declaration of Independence. Again, there's references to treaties that have been made. Well, a treaty can't be made by a country that doesn't exist. The nation exists. I'm laboring the point because many people think that the United States was created with the ratification of the Constitution, but that is certainly not the case. It was already there. It was already in existence, and the very fact that the Constitution presupposes that point is a way of endorsing, embracing, and incorporating the Declaration of Independence in the Constitution at the time. And that, of course, includes everything the Declaration of Independence affirmed, including the fact that we are given by our Creator with certain unalienable rights, that all men are created equal, all of that language which refers to a God of heaven and earth who is responsible for us being here, is all incorporated by reference as well in the If you don't believe this, you should go back and read John Quincy Adams, the son of John Adams, who was one of the founding fathers, of course, gave a speech, and this was 50 years after the installation of George Washington as the president, the first president of the United States. John Quincy Adams, on this Jubilee celebration, as it was called, because it was 50 years down the road, reminds people emphatically of exactly what I'm saying here. I'm not saying anything more than John Quincy Adams was saying, and he obviously was speaking to people who would have assumed that what he was saying was in fact the truth. He's simply reminding them of it. But listen to this language from John Quincy Adams, quote, "Fellow citizens, the Ark of your covenant is the Declaration of Independence. Your Mount Ebal is the Confederacy of Separate State Sovereignties, and your Mount Gerizim is the Constitution of the United States." That language is remarkable, isn't it? Of course, alluding to the children of Israel when they entered the Promised Land, and one of the first things they did was remind themselves of the great law that had been given through Moses. And you had part of the representatives of some of the tribes on Mount Ebal, and some of the tribes on Mount Gerizim, and the people in the middle, and then they read these stipulations and terms. The law of God is given through Moses to the people. And John Quincy Adams here is saying, fundamentally, we are in the same position now, 50 years down the road. Our Mount Ebal, our original defining document, is the Declaration of Independence, and our Mount Gerizim is now, 50 years later, recognizing the Constitution of the United States. Lawyers, I practiced law for a while, of course, and in the context of doing that, occasionally would create corporations. People would come, they want to start a corporation, and I told them, well, there's two things you need to do. One, articles of incorporation. And the articles of incorporation create the corporation. It's a public entity. You file it with the Secretary of State, and at that moment, when it's stamped and signed and so on, a corporation comes into being. But step two is you need bylaws. Corporations have to have rules by which they operate. And the bylaws are basically the rules that are going to govern when boards of directors are going to meet, and that sort of thing. It's the details of how the place works. But the bylaws presuppose the articles of incorporation. There wouldn't be a corporation for which there could be bylaws unless you already had the articles of incorporation. That's exactly what happened in terms of creating our country. The Articles of Incorporation were really embodied in the Declaration of Independence, and the bylaws, the rules by which we operate based on the country that's been created by the Declaration of Independence is what we call the Constitution. That's essentially what John Quincy Adams is arguing here. He says, in that scene of tremendous and awful solemnity narrated in the Holy Scriptures, there is not a curse pronounced against the people upon Mount Ebal, nor a blessing promised them upon Mount Gerizim, which your posterity may not suffer or enjoy from your and their adherence to or departure from the principles of the Declaration of Independence, practically interwoven in the Constitution of the United States. You hear that language? The Declaration interwoven in the Constitution of the United States. Lay up these principles then, Adams exhorts, in your hearts and in your souls, bind them for signs upon your hands, that they may be as frontlets between your eyes. Teach them to your children, speaking of them when sitting in your houses, when walking by the way, when lying down, when rising up. You recognize all of that, of course, is a language borrowed really from Moses as he was giving similar kinds of exhortations to the people there as they were going to enter the promised land. He says, write them upon the doorplates of your houses and upon your gates. Cling to them as to the issues of life. Adhere to them as the cords of your eternal salvation. And he concludes, so may your children's children, at the next return of this day of Jubilee, 50 years hence, after a full century of experience under your national constitution, celebrated again in the full enjoyment of all the blessings recognized by you in the commemoration of this day, and of all the blessings promised to the children of Israel from Mount Gerizim as the reward of obedience to the law of God. So that's the idea, that the Constitution, it presupposes and rests upon the Declaration, and the Declaration, of course, has an outlook that is thoroughly compatible with the Christian faith, and in fact, really is presupposing it. Well, the main argument against the position I'm taking here, the one that's made repeatedly by people who want to deny that there's any kind of religious element to the Constitution, is what's called the No Religious Test Clause. There is a prohibition against religious tests. And the argument goes that, well, look, what part of that don't you get? If there's a prohibition against religious tests, then how can you say that the Constitution has any kind of religious underpinnings? Well, let's take a look at it. This is in Article 6 of the Constitution. And it affirms several rules concerning people who are going to be sworn into office. And it says, in part, quote, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office of public trust under the United States. All right, there it is. That's the language. And that language is repeatedly raised as an argument to say that there is no religious element in the Constitution, that it is indeed a godless Constitution, as is argued by Kramnik and Moore. They would say that election campaigns must be void of religious content. They don't want any person running for public office to make any reference to any kind of theological outlook, and they believe that that is being precisely prohibited by the Constitution. They say on page 168 of their book, quote, the godless politics dictated by the no religious test clause means that a person's religious faith or lack thereof should never be an issue in partisan politics. They use as a bad example from their point of view the case of Senator Phil Gramm, saying, quote, Senator Graham's shameless advances to the Christian right provide an especially vivid example of what we condemn. In campaign speeches, Graham paraded a belief in Christ's second coming to win votes. By doing so, Graham ostentatiously violated the Jeffersonian view that politicians, in deference to the no religious test clause, should keep their religious opinions to themselves. Well, that's the view they took. This no religious test clause should prohibit people running for public office and those holding public office to ever use religion in any sense as part of their political outlook or their political rhetoric. Political debates, they would say, must be void of religious claims. They said, quote, "It is not legitimate for political leaders to mobilize religion in order to invest their argument about moral consequences with certainty." They say on page 175, "What is unacceptable in light of the godless Constitution is for religious certainty ever to trump politics, and for governmental policy in any way to privilege or codify religious belief in ways that preempt a pluralist democratic process." Legal scholar Herb Titus, summarizing the views of Kramnik and Moore, says, quote, "In summary, Kramnik and Moore have contended that the, quote, no religious test clause demands religious neutrality in the public affairs of the nation, thereby ensuring a public policy free from religious correctness." You've heard of political correctness. Well, this is sort of a prohibition of anything that we would call religious correctness. All right, well, what are we going to do with that? What's exactly the way to deal with it, how to view it? We do have, of course, this prohibition, no government-mandated religious test. But if you think about it for a moment, you realize that's a very narrow restriction. Now, just work with me here. The text says a religious test may not be required. It does not say a religious test may not be permitted. And while that may seem like a tiny distinction, there's a world of difference between those two. The clause does not prohibit a person running from public office to voice their religious outlook. It doesn't prohibit them from, in fact, invoking a religious outlook when they take an oath or any other related thing. Presidents of the United States will add on their own volition to the oath of office that they are going to uphold the Constitution of the United States, so help me God. Well, that's a religious affirmation. Nobody's rising up in protest and saying that violates the no religious test clause, because the state is not requiring it. It is permitted, but not required. The state is not permitted to say to a person, now look, you cannot have this office unless you subscribe to the following religious doctrine. That's not permitted. And rightly so, it shouldn't be permitted. But for a person who's running for public office to give free and clear voice to their religious outlook is certainly permitted, and in fact, I think encouraged in the general view. The presidents will put their hand on a Bible. Well, what is that but an endorsement of that book, and using it as a solemn foundation that gives underpinnings to the oath that they're taking. So we find throughout our history that religious leaders have voluntarily sworn taking a religious oath. I might add, by the way, that the prohibition, the no religious test clause, is a principle that binds government authority. Government may not force a person to take a religious test. There's nothing prohibiting, you might say, people-imposed religious tests. If somebody's running for public office and I'm interested in, what their outlook is, what their values are, I might very well ask that person, well, what's your religious outlook? Are you a Methodist? Are you a Baptist, a Presbyterian, a Catholic? What are you? I'm perfectly free to ask that question. Are you an atheist? That may influence whether I vote for you or not. That's a people-imposed religious test. They don't have to answer it. I'm not the state. I don't have authority to enforce them, to make them somehow subscribe or not subscribe to a religious view. It's their freedom. They're permitted to give an answer or not, but it may very well influence how I vote, because that's permitted. The Constitution doesn't prohibit exploring a person at that point. It does prohibit, however, a government-mandated religious test, and rightly so. That's precisely what it should do. In fact, there has been a huge danger down through history of state-imposed mandatory religious tests. Oliver Ellsworth was the second Chief Justice of the United States Supreme Court. And he said in an opinion that came before him, quote, "The business of civil government is to protect the citizen in his rights. Civil government has no business to meddle with the private opinions of the people. I'm accountable not to man, but to God for the religious opinions I embrace. A test law is the offspring of error and the spirit of persecution. Legislatures have no right to set up an inquisition and examine into private opinions. I'm afraid there's some Christian people that don't get that. I sometimes hear from them that they think that we should be exacting religious commitments from people as an official, authoritative demand by the state. Well, that's a dangerous business indeed, because the state has coercive power. And when you start using the power of the state to coerce religious confessions from people, you are not far from inquisition. You're not far from persecution. And that's why wisely the framers of the Constitution created religious freedom, because it is not the business of the state to extort from people religious confession. It is the business of the state to restrain evil. It's the business of the church to set forth standards that we should aspire to. And there's a very big difference between those two. The state should create peace so the church can do her business. The church should support the state in the sense that the church is abiding by the reasonable rules of conduct and so on, and the two should live together in a harmony. But there should certainly not be any sense in which the state is beginning to intrude upon the province of the church in connection with such matters. Isaac Backus was a delegate to the Massachusetts Ratification Convention. He said, quote, "Nothing is more evident both in reason and the Holy Scriptures than that religion is ever a matter between God and individuals, and therefore no man or men can impose any religious test without invading the essential prerogatives of our Lord Jesus Christ. And let the history of all nations be searched, and it will appear that the imposing of religious tests has been the greatest engine of tyranny in the world." And I'm going to tell you that is not hard to prove historically. And so let's just be cautious when we start thinking that the state should be exacting from people some sort of religious commitment. That's dangerous business, even if we agree with the commitments that are being exacted. You see, it's a slippery slope that can often take us to a very bad place. This is really just a species of the rule that was announced by Jesus to render unto God what is God's. You know that James Madison, who is sometimes called the father of the United States Constitution, he wrote the original draft, which was then, of course, subject to a fair amount of debate and discussion at the Constitutional Convention. But James Madison was trained by John Witherspoon. He went to the College of New Jersey. John Witherspoon was a Presbyterian scholar, pastor. He was the president of the university. He had such an influence on Madison that Madison, for a time, was planning to become a pastor. That was his plan, to become a Christian pastor, presumably Presbyterian. That was the major influence then in his life. But John Witherspoon, at least by external evidence, seems to have suggested to James Madison that it might be better for him to go in a different direction. Witherspoon certainly kept Madison around for private instruction for another year. This was private instruction between John Witherspoon and James Madison. This is like getting a master's degree. And so the two of them worked through principles of political theory that derive from the Presbyterian outlook, which trace back to John Calvin. It was 1 year of intense study. And I'm going to tell you, if you understand that particular outlook and then read the Constitution, you're immediately impressed with the fact that Madison was a good student. He is not imposing religious sanctions. You know, sometimes people look at Madison and they say, well, he didn't say much about his religious outlook. Well, his history made that perfectly clear. But when it came to political life, he realized the proper role of the state, and he was very careful, therefore, when he was describing how the state should operate, not to overstep the bounds. He was very respectful of exactly what the principle is that we're dealing with here. Madison said, for example, "Whilst we assert for ourselves a freedom to embrace, to profess, and to observe religion, for which we believe to be of divine origin, we cannot deny an equal freedom to those whose minds have not yielded to the evidence which has convinced us." You can't put a gun to someone's head and demand that they subscribe to a certain religious outlook. That never ends well. And those people who think we should do something like that are misguided in the extreme. And it's part of the reason that our wise founders avoided any such abuses. If this freedom be abused, he says, it is an offense against God, not against man. To God, therefore, not to man, must an account be rendered. That was James Madison in his memorial and remonstrance against religious assessments. So, I know that the no religious test clause of Article 6 is sometimes used as an argument that the Constitution is a godless document, but I really think with a little closer examination, it becomes pretty obvious that that particular argument really doesn't hold a lot of weight. I think the most weighty case in favor of the idea that the Constitution reflects a Christian outlook is the fact that it is fundamentally organized along what's called biblically a covenant. This is an important point, and it's often missed. And so I want to finish by just highlighting this a little bit. The Constitution is based on the biblical idea of covenant. Covenant is traced especially to the Reformed side of the Protestant Reformation. Luther didn't say as much about this, but John Calvin certainly championed what was called covenant theology, and that did translate into some political ideas as well. Emilio Castelar was a great, very famous Spanish statesman writing in the mid-1800s, and he was no friend of the Protestant Reformation. He was a Catholic, you know, and a thoroughly committed Catholic, but he was a very fair historian. And he makes a very interesting comparison between the revolutions that had taken place in recent history. The American and English Revolution on the one hand, the French Revolution. He didn't know about the Russian Revolution, that came later, but he's contrasting them, and it's interesting to see how he does this. This is from Emilio Castelar, now writing in 1872. By the way, this is in Harper's, number 266, volume 45. You can find it at page. Quote, "The French democracy has a glorious lineage of ideas, the science of Descartes, the criticism of Voltaire, the pen of Rousseau, the monumental encyclopedia," that was from Diderot. And the Anglo-Saxon democracy, on the other hand, he says, for example, what you find in America, has for its lineage something else, a book of primitive society, namely the Bible. He says the French democracy is the product of all modern philosophy, but the Anglo-Saxon democracy is the product of a severe theology learned by a few Christian fugitives in the gloomy cities of Holland and Switzerland. You know, like I say, he wasn't a friend of the Reformation, but nevertheless, he's giving credit where credit is deserved. He says the French democracy is passed like an orgy of the human spirit, drunken with ideas, but basically passed into oblivion. But the Anglo-Saxon democracy has produced that legion of workers, and it remains. The idea of a covenant, recognized as a distinctively Protestant notion flowing out of the Reformation, was implemented by the Puritans. You know, you have the Mayflower Compact, for example, Massachusetts Bay, with the documents worked out by John Winthrop, has a similar kind of constitutional, you might say, covenant basis for the society there. This is from the American Bar Association Foundation. The American Bar Association Foundation, in a document called Sources of Our Liberties, page 57. This was published in 1976. Listen to this language. The document, referring to the Constitution, represents the application to the affairs of civil government of the philosophy of the church covenant. This theology found in the Scriptures the right of men to associate and covenant to form a church and a civil government, and to choose their own officers to administer both religious and civil affairs. That's not a religious institution speaking there. That's the American Bar Association, and it's pointing out what is quite obvious to anyone who studied this with an open mind, that the Constitution is rooted in that biblical idea of covenant, which was championed in the Reformed side of the Protestant Reformation. Helen Sylving is a legal scholar. She wrote in a book called Sources of the Law, page 56, published in 1968, quote, "The words compact and consent are not of recent vintage in political and legal thought. They rather derive meaning from the history of ideas traceable to remote ages of the development of the Judeo-Christian culture." She says, quote, "The law of the Old Testament was based upon a compact, and the ethics of the New Testament were reformulated in terms of a new covenant or compact. In this religious form, the principle of compact was imported into this country by the early colonists who came carrying their Bibles both in heart and in hand." She says, quote, "The religious view of the state contract was translated into political principles, As political principles, they were adopted by the framers of the American political and constitutional doctrine. It's derived from the Bible. The Bible has this idea. Probably the greatest legal scholar in the very early years of our country's existence was a man named David Hoffman. He was universally regarded as the leading legal scholar of the day. He offered a course in legal study. This was in 1836, and in his introductory lecture he would say, quote, "The Bible forms the very natural introduction to this course, as recording a form of government and law originating in the great legislator of the universe." Well, if we have an idea of covenant, then that is the notion that gives rise to our principle of consent of the governed. You see, a covenant is based on consent. People consent to it, and we, of course, have championed consent of the governed. It was part of the driving force behind the revolution, was that we believe that England was denying consent of the governed. The Declaration of Independence said governments derive their just powers from the consent of the governed. That was an idea rooted in the notion of covenant. Again, Sylving says, in view of the Old Testament rule of anyone requires a justification beyond faith or belief in the righteousness of one's cause. It's not just that I believe that I got the right answer. That's not going to do it, you see. Even if I do have the right answer, that's not a legitimate basis for the authority. It requires consent of the governed, and that is rooted in the idea of a covenant or a contract. She says, quote, "All basic principles of democratic law share this element of the necessity of giving an account for authoritative action over and above its eminent merit." It's not just the merit of an idea, it's the consent of the people who are going to voluntarily bind themselves to that particular idea. The American Revolution was thought on that principle. The statement, "no taxation without representation," came immediately out of that. That was exactly why it was stated. They weren't objecting to taxes, that wasn't the problem. They were objecting to taxes that were being imposed upon them without any particular opportunity to consent, to participate in the legislative process that gave rise to the tax. And it was that became the triggering event, as you're well aware, of the American Revolution. Well, if you have consent of the governed rooted in the idea of covenant, then of course that in turn gives rise to the idea of rule of law. Again, Sylving says, as all political ideologies, the philosophy of governments of law, which you find in Montesquieu, or the rule of law, which you find in Samuel Rutherford, in civil and common law tradition, is of theological origin. Rule of law as contrasted with rule by force alone. Always beware of politicians who want to rule by force alone. It's very tempting, and you give some people power, you give them authority, you give them that kind of carte blanche to throw their weight around, and they will do it. As Madison said, if men were angels, we wouldn't need government, but in fact, men are not angels, and you start giving them a gun and they'll shoot it. That's the idea, and so at this point, the warning is against giving that kind of authority. It has to be the rule of law. So it's the rule of law contrasted with rule by force alone refers to a special type of justification, namely consent. Consent to the authoritative action, that is its legitimization. So when we speak of the Constitution, we call it the supreme law of the land because we are governed by law. And where did the authority of that law of the land come from? John Marshall, the first, one of the very early justices of the Supreme Court, a famous, of course, legal scholar, said, quote, "The original right of the people to establish for their future government as principles as, in their opinion, shall most conduce to their own happiness." It's the people who create a covenant reflected here in the Constitution that gives rise to the rule of law. The source is derived from consent of the governed in written form. Again, Marshall said in Marbury versus Madison, important case in our early years, quote, "The government of the United States has been emphatically termed a government of laws and not of men." All right, well, that's my case, at least in a preliminary way, for the idea that our Constitution is rooted quite clearly in an idea that is distinctively Christian, filtered through the Protestant Reformation, but certainly they were deriving their understanding from biblical sources, and that was pretty much universally understood for many, many years in our history. It's only been the rise of a radically secular culture in recent years that has tried to rewrite history such that that particular aspect of our tradition is lost. So, an answer to the question, is the Constitution a Christian document? My answer is yes, it is. In fact, I don't think it's hard to prove. I think anybody that has a sober assessment of the historical evidence is going to reach a conclusion along those lines. I hope this has been helpful to you. Again, part of the reason that I do this is because, as you know, I in the mid-1980s became a lawyer, and part of what happened in that was I stood up in a courtroom one day and I raised my right hand and I swore to, among other things, uphold the Constitution. Well, I take that oath seriously. You know, if I've sworn to uphold the document, then it seems to me that that's exactly what I'm bound to do. And so over the years, I've taken the opportunity from time to try to rise in defense of our Constitution and its original meaning and its purpose and the way it should be worked out. And this is just one more installation in that particular effort. Thanks again for joining us. As I say, this will be the last of these uploads for a while. We'll probably return to this series at some time in the hopefully near future, but it won't be for a few weeks. So I've appreciated having you along. I hope that God is blessing you richly and your family and all that you're involved in. And until we see each other again, may God richly bless you.